This is Duke University.
My name is Neil Siegel, and I co-direct the program in public law here at Duke Law School. There is a buzz in the air today at Duke, not just in the law school, but around the campus. You might think, why? It's October. The men's basketball tournament is not beginning. It can't be that. What could it be? It's First Monday. I wish you all a happy First Monday. Today, the October 2011 term of the Supreme Court of the United States officially begins. At around 10 o'clock this morning, the court issued orders denying certiorari in many cases and inviting the Solicitor General to submit briefs expressing the views of the United States in 5 cases. And when I say inviting the Solicitor General, what that means is politely ordering the Solicitor General to file briefs with the court. The court also heard oral arguments in 2 cases this morning and is scheduled to hear 7 this week. So far this term, the court has agreed to hear 48 cases on the merits. That's a little more than half than I imagine the court's going to decide on the merits. Last term, the court issued 82 opinions deciding the merits of 84 cases. For those who are counting, 20 of the 48 grants are from the U.S. Court of Appeals for the Ninth Circuit. So the court grants more Ninth Circuit cases than any other circuit. That continues a trend. Typically, the court doesn't grant to affirm, but sometimes it does. Just like in sports, you got to play the game. You have to see what happened. 10 of the grants are from state courts, right? So majority from federal courts, more from the Ninth Circuit than any others, but 10 cases from state courts as well. Joining me today for our preview of the October 2011 term are 2 Duke Law professors, Curt Bradley and Sachs, and 1 Duke Law student, Emily May, who knows quite a bit about the case she is going to discuss. And in fact, we'll begin now with Emily's presentation. There are a number of very significant criminal cases on the docket this term. One case involves whether the Fourth Amendment allows law enforcement to conduct strict searches routinely of all people who are detained, even for minor offenses without any kind of individualized suspicion. That's the case of Florence against Board of Freeholders, and a case called Maples against Thomas, in which Duke Law School's own Deborah DeMott is playing a very prominent role. She filed an amicus brief in that case. The question is whether a missed deadline, which results from a screw-up in the mailroom of a prominent New York law firm, can be attributed to a death row inmate who otherwise is not going to be being able to appeal his conviction and sentence. In a case called Perry against New Hampshire, the court is going to consider eyewitness identifications, which have been very much in the public eye lately, and specifically whether eyewitness IDs made in suggestive settings are subject to special judicial scrutiny, even if the police were not responsible for the suggestiveness of the situation in which the ID took place. Emily's going to talk about what's perhaps the most prominent criminal case on the docket so far, a case called United States against Jones. Many of you may be familiar with this case. It was the Hart Cup problem from last year. And Emily, who won that competition, knows the case well. The question presented is whether the Fourth Amendment, whether it violates the Fourth Amendment for the police to attach a GPS device to a suspect's car without a warrant and continuously track its movements for weeks at a time. Emily.
Thanks, Professor Siegel. Well, as Professor Siegel noted, this case, United States versus Jones, has been getting a lot of attention. And indeed, the New York Times recently said that it's the most important Fourth Amendment case in a decade. And at its heart, the case is about whether attaching a GPS tracking device to a suspect's car without a warrant and tracking the car's movements for a prolonged period violates the Fourth Amendment. And in this case, police began investigating Antoine Jones, the respondent, who owned and operated a D.C. nightclub for suspected drug trafficking. And during the course of their investigation, police attached a GPS device to Mr. Jones' car without a valid warrant, and the device tracked the car's movements on public roads 24 hours a day for 28 days. And from this GPS data, the data indicated that Jones had visited a suspected stash house, which the government subsequently used at trial. And at trial, Jones was sentenced to life in prison. but the D.C. Court of Appeals reversed his conviction, holding that there had been a Fourth Amendment violation. And the Supreme Court hasn't yet addressed this issue because GPS technology is relatively new, but the court has in the past addressed technology and the implications of various technologies on Fourth Amendment rights. And in Katz versus United States, which is one of the biggest cases in this area, which the court decided in 1967, the court held that the use of an electronic listening device attached to the outside of a public phone booth constituted a search under the Fourth Amendment. And since Katz, the court has followed a two-part test. The first inquiry being whether the individual, by his conduct, has exhibited an actual subjective expectation of privacy. And the second inquiry is whether that actual subjective expectation of privacy is considered reasonable by society. Now, the court has decided a case that was somewhat similar to this one in 1983 in United States versus Knotts, but the technology was much different. It was the use of a beeper device to aid in tracking a suspect on a 100-mile journey on public roads to a drug lab. And the court held in that case that it was not a search. And there are two differences. One being, like I mentioned, the type of technology is much more primitive than the GPS at issue now. And also in Knotts, it was for a single discrete trip, albeit a very long trip, 100 miles, but still a single trip versus continuous monitoring. Two other federal appellate courts have upheld the use of GPS devices without warrants in similar cases, the idea being that we don't have an expectation of privacy in public places and that it's not a constitutional violation to make law enforcement's job easier and more effective. But the D.C. Circuit has disagreed in what one commentator calls a visionary ruling by Judge Ginsburg. And the D.C. Circuit held that Knotts, the beeper case, didn't govern here because the court explicitly reserved the question of whether a warrant would be required in a case involving prolonged 24-hour surveillance. And in the Court of Appeals opinion, Judge Ginsburg argued that no reasonable person expects the government to track his movements 24 hours a day for a prolonged period, and that moreover, we have an expectation of privacy in the whole of our public movements. And in his opinion, Judge Ginsburg employed the mosaic theory, the idea being that there's a difference in kind, not just a difference in degree, not just a difference in the volume of information between the long-term monitoring at issue here and the short-term monitoring at issue in Knotts. That long-term monitoring provides a more intimate picture of one's life, and that a reasonable person expects the various trips he takes to remain disconnected and anonymous. If the Supreme Court decides to adopt this mosaic theory, it could provide a way for citizens to push back against prolonged government monitoring. So on appeal, the Supreme Court is considering two questions. One is the question that Judge Ginsburg wrestled with, namely whether this type of continuous GPS monitoring constitutes a search in violation of the Fourth Amendment, but also second, whether the attaching the device to Mr. Jones' car is a violation of the Constitution, and that's something the Court of Appeals didn't really address. Both parties argue, as you might expect, that the stakes are very high. The government's arguing that the adoption of this mosaic theory would deeply unsettle Fourth Amendment law and have a negative impact on a host of standard police practices, such as prolonged visual surveillance. The respondent has a much different worry and argues that if GPS surveillance is not a search, then the government could go much farther, could attach devices to our briefcases, our books, our clothing, and monitor us. And it's sort of an Orwellian Big Brother type concern that if the government can do this, like they did in Jones, what can't the government do? It's very much being debated in the media, as I mentioned, and the Supreme Court is planning to hear arguments for it on November 8th, 2011.
Okay. Well, thank you very much, Emily. We're going to turn now to Curt Bradley, who is going to discuss the Jerusalem passport case, Zivotofsky against Clinton.
Thanks, and welcome, everyone. So the case I'm going to describe for you is a case that concerns really a longstanding issue of U.S. foreign relations, particularly U.S. relations in the Middle East. And Zivotofsky versus Clinton specifically concerns a statute that Congress enacted in 2002, and the relevant part of the statute mandates that when a U.S. citizen is born in the city of Jerusalem, the Secretary of State, if the child or parents request it, the Secretary of State must record the place of birth in the passport as Israel. This statute is actually part of a long-running dispute between Congress and the executive branch over U.S. policy towards Jerusalem. Israel, as you probably know, has long maintained that Jerusalem is its capital, and it has exercised control over, well, first the west part of Jerusalem since really the founding of Israel in 1948, and then over the eastern part of Jerusalem after the 1967 war. Much of the rest of the world disagrees with Israel's position in this regard and views at least the eastern part of Jerusalem as constituting occupied territory, as the rest of the world views the West Bank in general and the Gaza Strip. And of course, the Palestinians argue that at least the east parts of Jerusalem should be part of a future state of Palestine, an issue very much in the news at the moment as the Palestinians are seeking to press their views on this in the UN. In general, particularly in the last couple of decades, Congress has been quite supportive of Israel's position with respect to Jerusalem. The executive branch less so. The position of the executive is that the status of Jerusalem is a very important question that needs to be worked out in negotiations between the Israelis and the Palestinians. And in fact, when there have been, not at the moment, when there have been active negotiations between the two sides, both sides have described Jerusalem as one of the core issues that needs to be worked out. Congress has done other things at various times to try to force the executive, in one instance in the 90s, to actually move the U.S. embassy from Tel Aviv to Jerusalem. They threatened to perhaps tie funding on the diplomacy to doing that. President Clinton's lawyers in the 90s advised him that this would be unconstitutional, invading the president's foreign policy powers. And Congress backed off a bit and allowed presidents to waive off these funding limitations, and all presidents have since used the waiver provision. When the 2002 passport law was enacted, it was under the Bush administration, and Bush lawyers advised him that it was unconstitutional, and he issued a signing statement, one of many signing statements, said that he would just treat this as an advisory view of Congress and not as binding, because, as he said about a number of views from Congress, and he said that otherwise it would impermissibly interfere with the president's constitutional authority to formulate the position of the United States, speak for the nation in international affairs, and determine the terms on which recognition is given to foreign states. The specific case here, the Zivotofsky case, arose when American parents had a child in west part of Jerusalem and then sought to have the Secretary of State record the place of birth in the passport as Israel. The State Department, consistent with its very long-standing practice, said no, and just listed, as it has done for a long time, the place of birth as Jerusalem. So the parents sued the Secretary of State and generated this case. Went to the D.C. Circuit Court of Appeals, and it was dismissed under what is called the political question doctrine. Probably most of you have studied this. Under that doctrine, courts consider a variety of factors in deciding whether a case poses a non-justiciable, non-judicially resolvable political question, including whether they think the text of the Constitution commits the issue in question to a non-judicial part of the government. There was a concurrence in the case, and I think it'll turn out perhaps to be quite an important one, by Judge Harry Edwards, where he said he thought the majority was quite wrong about the political question doctrine. It's not a political question in his mind, but he ruled for the government. He would rule for the government on the merits. His view was that this passport statute indeed infringed on the exclusive authority of the executive. So those are the two issues now before the court, and the case will be argued in November 7th. First, does this effort to get the Secretary of State to follow the passport statute raise a political question that the courts cannot resolve? And if it doesn't, if Judge Harry Edwards is right, does the statute unconstitutionally invade the executive's authority? Just a couple of quick thoughts on that, and I'm happy to talk more about it in the question if we have time for questions. On the political question doctrine, I think there's a good chance, is my view, that the court will end up agreeing with Edwards that the doctrine does not apply here. A couple of reasons for this. One is the court in general has not shown a great enthusiasm for the political question doctrine in the last couple of decades or so. If you think about a case like Bush v. Gore, quite a political case, quite a sensitive case, but no political question doctrine being invoked in that case. All the war on terror cases from the last decade, those were quite sensitive national security cases, and the court routinely is deciding them. But more fundamentally, what this Zivotofsky case may be most important for is highlighting what I believe to be an incoherence in the political question doctrine that is particularly vividly illustrated here. Why did the D.C. Circuit say this is a political question? They said it was a political question because Congress has invaded the exclusive authority of the executive branch. Now, if you listen to that, that sounds exactly like the claim the executive is making about the merits. And in fact, I just read the government's brief, and they acknowledge in their brief that our argument on the merits overlaps to a considerable extent with our argument on the political question doctrine. In fact, they're the same exact arguments. That is, the text of the Constitution, read in light of history, gives the executive branch the authority to decide how to deal with Jerusalem. Congress cannot invade that. And that's the argument they make about why this is a political question and why they should, if it's not a political question, win on the merits. That is really not what we tend to think of as a political question in the sense of it being non-justiciable. To decide the political question here is to decide the merits of the case. And I don't see the purpose, in fact, of calling that political question, except in the sense that it's about the political branches. But that's not the same as saying the courts cannot decide because they lack the tools or the means to decide a case, which is a different sort of, and I think what most people view the political question doctrine as about. And this case nicely highlights it because the only factor being used for the political question doctrine is the idea that the Constitution commits it to the executive, a pure merits type question. I think the court might agree with Edwards that, in fact, this is a merits question, and we'll just go right to the merits. On the merits, just give you my views again, but I think there could be quite reasonable grounds for disagreement with me, which is I think the government will win on the merits if they get to the merits, which is to say, interestingly, the Constitution doesn't say anything about the president's power to recognize foreign governments, which is the power in question here. But really, since even the George Washington administration, presidents have insisted that their power to deal with ambassadors, including receiving ambassadors, implies the power to decide for the United States which is, say, the lawful government that's sending the ambassador. It happened actually when France was going through a revolution in the Washington administration. The United States actually had to decide, are we going to receive the new ambassador from revolutionary France? And the Washington administration adopted the argument that it's up to the executive to decide which government is the lawful representative of France, and therefore which ambassadors to receive. And executives have claimed that for more than 200 years, most of the time with Congress's acquiescence, a few times not, but almost every time Congress has tried to intrude on this, the executive has successfully pushed back and won those battles. So if you look at the long period of historical practice, there's a good argument for a presidential authority to recognize foreign governments. And it is not a big stretch to say that includes the ability to decide what that government's territory includes and what should be left open and not recognized by the United States, which obviously would include potentially Jerusalem. And this passport statute, by mandating that an official government document associate Jerusalem with Israel, could reasonably be said to invade the executive's decision on this, which is to leave that issue open for negotiations between the Israelis and the Palestinians. But again, there are obviously arguments that could be made the other way. In any event, this case, I think, it could be quite important on two fronts. One is clarifying, at least in my hope, the political question doctrine, which has often been very vaguely dealt with by the court in the past, and potentially also the scope of the president's power to decide for the United States the U.S. relationship with foreign governments.
Well, thank you very much, Professor Bradley. We're going to turn now from foreign relations law to Clause 8 of Article 1, Section 8, specifically the Progress Clause, where Professor Sachs is going to discuss the case of Golan against Holder.
Yes, thank you very much. Yes, I'm here to discuss Golan v. Holder, which the court is going to hear on Wednesday. This case concerns whether Congress can, in any circumstances, place a work that's fallen out of copyright into what's called the public domain, back under copyright, and if it can, what the limits are on that power. I should say right out, as a matter of full disclosure, that I worked on this case on the government side as a summer intern for the Department of Justice in 2005. So nothing that I'm saying represents the government's views. These are all my views, and I'm not revealing any non-publicly available information. For a long time, copyright law treated works by foreign authors differently from works by American authors. So, for instance, in the early part of the 20th century, you may have heard that the United States and Russia had various disagreements. And for one thing, they didn't respect our copyrights, and we didn't respect theirs. Also, countries tended to have very different formalities that attended copyright. If you wanted to register your book as a copyrighted book, you had to put certain labels on it. But in Russia, you had to put different labels on it that weren't like our labels. And if you didn't have our labels, then we would say, no, that's not copyrighted. So in any case, you had a wide variety of foreign works that would otherwise be copyrightable, but were not for either because of this national-based discrimination or because of formalities. So an example of this would be Prokofiev's Peter and the Wolf, which is a common piece to be played for children's concerts, and one of the reasons it's so common is that it was written by Prokofiev, who is from Russia, and therefore was not copyrighted, so that the orchestras didn't have to pay any royalties if they wanted to play Peter and the Wolf. So in the 1990s, as part of the negotiations that later produced the World Trade Organization, countries agreed to respect each other's copyrights and to reduce the level of formalities that would be required. And Congress implemented that through what is called the Uruguay Round Agreements Act of 1994, which, among other things, gave to what were called restored works, so things like Prokofiev's Peter and the Wolf, the remainder of whatever copyright term they would have had if they had been properly registered and accepted to start off. So, for instance, Prokofiev died in 1953. Copyright term in the US is currently life plus of the author plus 70 years. So Peter and the Wolf gets the remainder of its copyright term until the year 2023 under this law. And at that point, a group of plaintiffs challenged the law, including Lawrence Golan, who is a composer and conductor, and he wanted to continue performing Peter and the Wolf with his orchestra. And after some back and forth litigation, the US Court of Appeals for the 10th Circuit upheld the law and said, yes, this is constitutional. Congress is able to restore to these works the latter half of their copyright. Golan petitioned to the Supreme Court, which granted certiorari, and here we are. Golan argues that the law is unconstitutional for two reasons. First, that it violates what could be called the Progress Clause or the Copyright Clause of the Constitution, which gives Congress power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Golan argues that if Congress can take something that's in the public domain and put it back under copyright, someone's exclusive control, it'll make that copyright term effectively unlimited. Because even if you have a public domain work, you never know that it's going to be public domain. Maybe one day Congress will give it back to the original author. And there's no limit that you can count on and invest on the basis of. You know, if somebody has just scheduled a performance for next year of Peter and the Wolf, they might discover, oh no, you know, now it's back under copyright. Or to have sort of the crazy example, if you're about to produce a new edition of Shakespeare, you just find out that Congress decided to give the, you know, great-great-great-great-great-grandchildren of William Shakespeare, or however many generations it would be now, back the copyright in all of Shakespeare's works. So, you know, you could understand how that would be somewhat concerning. Golan also says that the law doesn't promote the progress of science and the useful arts because it doesn't provide any incentive for the creation of new works. You know, Prokofiev is dead, so giving him extra copyrights isn't going to cause him to write any more music. You know, giving royalties to his estate may or may not encourage authors to produce more works, which is the whole point of the copyright incentive. Now, a similar argument was made in an earlier case called Eldred v. Reno. That case involved the Sonny Bono Copyright Term Extension Act, which has been nicknamed the Mickey Mouse Protection Act because it was passed in part at the instance of the Walt Disney Corporation because Mickey Mouse was about to fall under copyright. The first cartoon was in 1923, and that was going to end. So what Congress did is it extended the term for everything that was under copyright for 20 years. And people raised the same sort of challenge. Look, Mickey Mouse is already here. Giving 20 years of extra copyright won't go back in time and give people incentives 75 years ago. But the court said, look, the Constitution says limited. 95 years is limited just like 75 years, and there's no warrant in the Constitution's text for taking that power away from Congress. Moreover, Congress had many times in the past extended the term of existing works, and the court said that was fine. Golan says that this case is different, though, because Congress generally has not taken things that were in the public domain back under copyright. And even though you can tell if you knew that Mickey Mouse is under copyright, you might not, you know, maybe you wanted to produce new copies of Mickey Mouse, but you knew that it was copyrighted, so you knew you had to wait until the term extended. Whereas Peter and the Wolf, people thought that they could produce as many copies of as they want, and then their expectations are frustrated. So that's the argument under the Copyright Clause. Golan also argues that the law violates the First Amendment, that Congress shall make no law abridging the freedom of speech. Ordinarily, banning publication of a book because its text is the same as some other book, would obviously be a content-based restriction on speech. But there's a recognized exception for copyrights because the same Congress that passed the First Amendment also passed copyright law, and everyone at the time seemed to think that they were consistent. So the court said in that earlier case, Eldred v. Reno, that there's no free speech problem if a law falls within what it called the traditional contours of copyright protection. So the issue here is that Golan argues that taking works out of the public domain is really rare, that's outside the traditional contours of copyright protection, and is problematic. So that's Golan's argument. What does the government say? First, with respect to the copyright clause, the government says that the law is fine because it keeps copyright to limited times. You know, if Prokofiev had lived in America, Peter and the Wolf would have been copyrighted from the day that it was written. People would have to pay royalties. And as it was, you know, the restored copyright doesn't last any longer than the copyright Prokofiev would have had if he'd been here. So how can you say that it's not limited? It ends on the same day. The U.S. argues that, in fact, it's even more limited because you know, he's only getting the last, 40-odd years of his copyright, whereas he would have gotten way longer if the law had worked otherwise. The government also says that restoring copyrights to things that fell into the public domain actually isn't all that unusual. A number of times in the 19th century through private bills, and again after both world wars, Congress passed legislation that said if there was some problem and you didn't comply with all the formalities and you didn't use the right labels, we'll forgive that. Even though your work really was in the public domain, as soon as you published it without the label, even though anyone could have copied it, we're going to forgive that and let you get your rights back. So, courts applying this doctrine in the patent cases, which rely on the same clause as copyright, said that was okay. So the argument is that that's fine for copyrights too. Finally, the government argues that under the First Amendment, that this doesn't go beyond the traditional contours of copyright protection, because what Prokofiev is getting is only what everybody else gets. It respects the distinction between copyrighting an idea, which you can't do, and copyrighting the expression of an idea, which you can. And it leaves the work subject to fair use, which is the exception for news reporting and scholarship and criticism. And these exceptions to copyright have been regarded as the way that copyright protects First Amendment interests. So that's basically the lay of the land as far as the arguments before the court. There's also a very interesting issue of whether the treaty power gives Congress more power to enact laws of this type than it would have in the absence of the Uruguay Round Treaty. But neither side is arguing that very much right now. The government wants it to be left back to the lower courts if they get back there on remand. Because I participated in the case, I'm not really going to say too much about where I think the merits lie or what I think the court might do. But I think the real key issue for the court will be how do you sort of draw a line between the Parade of Horribles examples, restoring copyright to Shakespeare so that no one can perform his plays without looking up who the, great-great-great-grandchild of Shakespeare is, and what seems like a relatively mild and reasonable measure of saying that, well, if you didn't get your copyright just because our country didn't like you, we can restore that, or if you messed up in some way with the formalities, we can forgive that and give you whatever's left of your otherwise perfectly acceptable copyright term. But whichever way the court rules is going to be one of the major decisions on the copyright clause.
Well, thank you, Professor Sachs. However the court rules, I think it's clear that if any of you serve as a DOJ intern at any future time, you too will be able to determine the government's litigation position before the Supreme Court of the United States. So those are 3 cases. I mentioned a few others, but those are 3 of the 48 that have been granted so far. Right? So we've chosen intentionally to go for depth over breadth. Consider this an invitation to look yourself at what's going on in the court's docket. I commend to you the SCOTUS blog website. It's really a wonderful resource, whether you're taking con law or any other related course. At the time, it's really a wonderful resource to see what's going on day to day at the Supreme Court. I do want to mention briefly 2 other cases that are on the docket, and I mean very briefly, and then talk a little bit about some very big-ticket cases that will or won't, depending on what the court does, make this case not just a significant term, which it's already shaping up to be, but probably the most significant term certainly of this century so far, if the court grants, and some of the cases I'm going to mention. But before I talk about what it is not yet granted, let me just mention FCC against Fox, This case is back at the Supreme Court. The first time around, it was an administrative law case. Now it's a constitutional case, a First Amendment speech, as well as a vagueness case, and it concerns something that whether or not you have children, you may be interested in, right? Which is, does the First Amendment allow the government to regulate cursing and nudity on broadcast television? The U.S. Court of Appeals for the Second Circuit in New York struck down the FCC's broadcast indecency regulations as unconstitutionally vague, and the court's going to hear now the constitutional challenge to these regulations. Just like the world has changed in terms of GPS technology, a lot has changed since the court held, I believe it was back in the 70s, invoking a scarcity rationale, distinguishing broader government regulation of broadcast TV from government regulation of speech and expression in other contexts, right? How many cable channels do you have at home, right? Well, you may not have cable, but if you do, you have many. And the idea that a scarcity rationale justifies the kinds of government regulations that would otherwise be unconstitutional seems hard to sustain. What will the court do in FCC against Fox? I also want to mention Hosanna Tabor Church against EEOC. It involves a conflict between federal anti-discrimination laws, including the Americans with Disabilities Act, and the religious freedom of groups who are, in some circumstances, immune from anti-discrimination lawsuits. And so here, the U.S. Court of Appeals for the Sixth Circuit in Cincinnati ruled that a commissioned minister who taught mostly but not exclusively secular subjects at a religious school could pursue an anti-discrimination lawsuit against the church that ran this school. And the question presented in this case is whether there's a ministerial exception to federal anti-discrimination law which would ban such suits, specifically suits between religious groups and employees whose work includes religious duties. Okay, let me talk now about 4 cases, 3 of which I think the court's going to grant soon and here this term, which again would make this term monumental, and 1, which I'll start with, which I don't think the court is going to grant. So there's been a lot of talk about the court possibly taking and deciding the issue of the constitutionality of state prohibitions on gay marriage. I don't suspect that's going to happen this term. Now, I say this with the caveat that I may not know what I'm talking about, right? The court gets to decide what it's going to do, at least much of the time. But here you've got the Prop 8 litigation in California, and you've got DOMA litigation. The DOMA case is being argued in the First Circuit in January. I don't see that being argued and decided right in time for the court to grant and decide it this term. I suspect it'll be another term. The Prop 8 litigation in California is now awaiting a decision from the California Supreme Court on justiciability on standing, and then it's going to return to the Ninth Circuit. So by the time that all goes through the legal procedures in the state and federal courts, again, I don't see same-sex marriage being decided by the court this term. I do expect it to be decided by the court over the next 5 terms. What about cases that I do think the court is going to grant? Well, there's the immigration case out of Arizona, Arizona against United States. I suspect the court is going to grant in this case. Here you have Arizona filing a cert petition on August 10th. The government's response is due on October 12th. And Arizona is seeking review of a Ninth Circuit decision which upheld the district court order enjoining the state from enforcing several sections, 4 parts of SB 1070, the state's controversial immigration law enforcement legislation. Among other parts of the law that the Ninth Circuit held were unlawful, preempted by federal law, is Section 2B, which provides that for any lawful stop, detention, or arrest made by Arizona law enforcement where reasonable suspicion exists that the person is an alien and is unlawfully present in the United States, a reasonable attempt shall be made when practicable to determine the immigration status of the person. So I think, as I say, the response is due on October 12th, and I suspect the court is going to grant in this case. What the court is going to do, I don't know. I haven't studied it enough. What I do know is that the court at least sent a signal last term in a case called Chamber of Commerce against Whiting that the court is not prepared to say all state immigration laws are preempted by federal law. The court upheld, in the face of a preemption challenge, another part of Arizona's immigration enforcement legislation in the Whiting case. And I think the court is going to take a careful look at federal law and state law and look for some kind of express or implied conflict. right? So the court at least has suggested that not all of immigration law is going to be covered by the federal government, and not all state law is going to be preempted. This specific case we'll have to see. The court, I think, is going to grant cert in a very important, the most significant development in constitutional racial equality, specifically affirmative action, since it decided the Michigan cases back in 2003. You remember the split doubleheader of Grutter against Bollinger and Gratz against Bollinger, and the court there said that race could be used as a factor in university admissions, used as a plus factor, right, as one among several criteria, but race could not be used in other ways. Race cannot be used in the form of a quota. You can't set explicitly a certain number of points, 20 points in the case of the Gratz case, the undergraduate college at Michigan, right? That's unlawful. So the court upheld some uses of race in university admissions. What's happening in this case, Fisher against UT Austin, is the day Grutter and Gratz were decided, UT Austin changed its undergraduate admissions criteria. It had used what's called the Texas 10% plan, in which if you were in the top 10% of your class, your graduating class in a Texas high school, you automatically got admission to UT Austin. After Grutter and Gratz come down, UT Austin retains that program, but layers on top of it the use of race as a criteria, first in admission and second in terms of selecting college majors and determining who gets which major to try and increase diversity, not just at the university level, but also at the classroom level. So now you have a constitutional challenge to this program which uses race as a factor. And specifically, you have an individual who was denied admission who didn't qualify under the 10% plan, and is saying that, that she had better credentials than a number of minority applicants who were admitted because of the race-conscious system, and she's saying that either that the Fifth Circuit, which upheld the program, either misread Grutter, or if the Fifth Circuit did not misread Grutter, then Grutter should be reconsidered. And so there's an explicit call in the alternative to reconsider Grutter. And of course, the single most significant development since Grutter and Gratz is the composition of the court, right? Because now you don't have Justice O'Connor, who voted to uphold the law school program in Grutter. You have Justice Alito, who has yet to cast a vote on an affirmative action admissions case. So the petition was filed on September 15th. The response, if it's not extended, is going to be due at the court on October 19th. Again, with the caveat that I may not know what I'm talking about, I expect the court is going to grant cert in this case. And then finally, the case I'm sure you're thinking of that I haven't yet mentioned, and that's the constitutionality of health care reform, the Patient Protection and Affordable Care Act. I suspect pretty soon the court is going to grant cert in one of those cases, and there are a number of vehicles it can choose from. So far, we have 3 federal courts of appeals who have weighed in on the constitutionality or at least some part of the litigation over the Affordable Care Act. The centerpiece of the law, it's a long law with many different provisions, and there are 25 or 30 challenges to many parts of it. To boil it down, the centerpiece of the litigation has to do with the minimum coverage provision, what opponents call the individual mandate, which requires most people lawfully living in this country to either obtain a certain minimum level of health insurance coverage or pay a certain amount of money each year. And those challenging the law argue that this individual mandate is beyond the scope of Congress's enumerated powers. They say it's beyond the scope of the Commerce Clause, for example, because it's a regulation of inactivity, and it's not a regulation of activity. They say it's beyond the scope of the Necessary and Proper Clause. They also say that it's beyond the scope of the tax power. It's not a permissible tax. It's an impermissible penalty. The government attempts to refute all of these arguments, and all the government needs to do is win on one of them. You had the Sixth Circuit upholding, rejecting a facial challenge to the law, upholding the minimum coverage provision. You had the 11th Circuit in Atlanta striking it down. Both decisions were 2-1, and then recently you had the 4th Circuit in Richmond dividing 2-1, but ruling for the government on jurisdictional grounds, finding that the plaintiffs in the 2 cases that the 4th Circuit decided didn't have either standing or else the court otherwise didn't have jurisdiction under what's called the Federal Tax Anti-Injunction Act to bring their claims. And so we'll have to see what happens. Here, I think I'm most confident that the court is going to grant, which may mean I'm most wrong, right? But you have two independently sufficient criteria for a cert grant under the Supreme Court Rule 10. You've got an important question of federal law that was struck down by a federal court of appeals, the one in Atlanta, and you have a split of authority, right, between two federal courts of appeals on an important question of federal law. And so now you have the government and the plaintiffs at least agreeing that the court should hear it and hear it soon. And so if the court does grant, the court will decide this case, like the others I just mentioned, by late June. And if you think about the timing, if it decides those three issues by late June, what else is going to be happening in the country by late June? Right, you're going to have the presidential election season heating up to a boil at that time, if not soon thereafter. And so we are certainly living in interesting times. Let me stop there and now open it up for questions. We can go until 1:20. Someone want to get us started? Shall I get us started? Yes.
Just a question.
I'm sorry, are you a student here? Are you authorized to be here? Okay. All right, Professor Blocher.
I have a question for Professor Bradley, actually, on the question of the political question doctrine. If the court were to revisit that and change it, I wonder if that might make it more likely that we would get at some point a merits decision on things like the constitutionality of the War Powers Resolution or targeted drone attacks and things which lower courts may be kicking now based on political questions.
Yeah, it's a good question. There are a lot of national security and foreign affairs issues that we haven't seen a lot of judicial involvement in, and some that you just mentioned, like the Libya war powers issues, and now people would like to challenge things like the drone attacks. In my view, there really are two types of political question doctrines. One is the incoherent one, I think, which I'm hoping they jettison in this case, which is to say, if you remember, Baker versus Carr has 6 factors. The first one is whether the Constitution textually commits the issue to another branch. I never understand that as a political question in the sense the courts can't decide. In order to decide whether that's true, they actually have to decide it. And this case, I think, poses that kind of political question, which is not really a political question. It's just a decision that, in fact, the Constitution lets the executive win or Congress win. Those other cases, war powers, drone attacks, might fall under a different political question doctrine, which I think you can at least argue for, which is there's just not enough traditional judicial materials out there to decide this in a principled way. And so we just kind of leave it to the political process to resolve it. We don't take a position, the court would say, as to whether drone attacks are in fact legal or whether the president can start war in Libya without Congress. We're actually not taking a position on that. We just don't think we have all the tools. And the rest of the factors that Brennan articulated in Baker versus Carr are about that sort of thing. They actually lack of judicially discoverable and manageable standards is the second factor. I think you can still argue for that kind, and that might still dismiss those cases you refer to, but not the cases where you actually have to decide the merits in order to say it's political.
Yes.
Professor Siegel, do you think it matters which case is the lead case if healthcare goes up to the Supreme Court, and does one side have an advantage being petitioner or respondent compared to the other, or is it just a free-for-all once it gets there?
The court's going to be aware, right? The court is already aware of everything that has been decided, and everything that will be decided, because there are appeals pending in other circuits, and they're going to have the benefit of that. They're not going to look more carefully at a certain court of appeals opinion because it's before the court or not. So in that sense, I don't think it matters. I do think it matters predictively whether the court grants the Fourth Circuit case, which is two jurisdictional decisions, versus the Sixth and 11th Circuit cases, right, which aren't jurisdictional decisions. That might give us some sense of how concerned the court is about jurisdiction. In one of the Fourth Circuit cases, only the Commonwealth of Virginia is the plaintiff, and so the standing of that state to sue is directly implicated. But the other Fourth Circuit case has private litigants, and the court said that there's a federal law called the Federal Tax Anti-Injunction Act, right, which precludes pre-enforcement litigation over the minimum coverage provision. You have to wait until the government tries to enforce it on someone to bring the suit. Now, that's also implicated in the other cases. It's just that the courts said that that wasn't a jurisdictional bar and they reached the merits. But if the court's going to reach the merits, I don't really think at that point, at least with respect to the minimum coverage provision, which is the part I know most. I know not all the same challenges are raised in all the cases. And the court's not going to decide a question about, say, under South Dakota against Dole, the constitutionality of expanding Medicare and whether that might raise a problem. That's not implicated in every case, right? But if the same question is implicated in more than one case, like the 6th or 11th Circuit, I don't see it making a great deal of difference. Other questions? Yes?
I have a question about, in general, the cases the court is hearing this term. Is the court moving away from its recent trend of hearing more business and corporate issues, or is there just a selection of cases that we're overviewing that the court already selected to heard haven't been as business focused?
I think in part it's a selection bias of what we tend to highlight for you here. I mean, I can't remember what else they're going over this week, but it's something about, like the scope of the Outer Continental Shelf Lands Act, and if you're injured on a drilling rig, whether the company pays or somebody. I mean, there are a ton of those cases too. They don't really make the headlines because very few people are interested in them. But I'm not sure as a percentage whether there's more or fewer business cases this year than other years.
You may have seen Justice Kennedy, I think, recently spoke to this a little bit, and he at least offered his perception, and I don't know if it's true, that there were fewer of the kind of big civil, commercial type cases kind of out there in the federal courts, because more of those parties are choosing to go through the non-court resolution through arbitration and things like that. I don't know if that's actually, but that was at least his perception, that he's seeing fewer of those big kind of business law type cases.
I mean, and it's also I do think it's true that so far this term compared to last, there are fewer business cases on the docket that business, by which I mean the Chamber of Commerce, which represents the interest generally well of business in the United States, views as hugely significant. If Walmart had gone the other way, hugely significant. If the global warming case had gone the other way in the Second Circuit, hugely significant. If the class arbitration case, AT&T Mobility versus Concepcion, had gone the other way, hugely significant for business, right? I don't see those cases so far this term, but that's very much a function of the docket and what's out there and what's percolating at this time. You're not talking about a lot of cases, a very big sample at any one time. I don't see any reason to conclude that the Roberts Court has made a conscious decision after those big cases last term not to do that this term. I mean, these wheels are set in motion well before the beginning of any particular term. Well, we have a minute left, so Emily, let me ask you a question, because as you were speaking about Jones, I was wondering do you have any sense of the extent to which the court is going to be thinking about terrorism and domestic terrorism in deciding the Jones case, right? Because it's one thing to be saying, well, what is it, Orwellian, that we're all, it's not like I often attach a GPS device to my students' cars to see if they're going to come to class, right? I don't do that a lot. But if you actually say we're tracking domestic terrorists, right, is that something you think is going to be on the court's mind?
That's something that I first thought of when I was actually looking at sort of the commentaries recently. And the editor of the SCOTUS blog in a podcast recently said that she thought the government was going to win pretty surely, just because in recent years the court, according to this commentator, has tended to interpret the Fourth Amendment much more narrowly than, say, First Amendment protection. And she said one of the concerns might be this sort of domestic terrorism. But besides the sort of oddball Osama bin Laden type question that the students in the Hart Cup had to wrestle with, it wasn't one of the things that was really addressed in the briefs.
Okay, thank you. Well, thank you to our very capable panelists today and to all of you for coming and participating.
Produced by Duke University. Online at duke.edu.